Hi, thank you for joining my webinar today, Protecting Brokers and Agents from Legal Jeopardy. Do not require written agreements prior to touring homes. All right, who am I? My name is Charles Jones. I'm an independent broker out of Austin, Texas. This is my 37th year in business. I'm a third generation broker. I'm a member of TAR and the Austin Board of Realtors. Why am I here and why am I involved? Well, by coincidence, in July of 2024, I had a client who is a former DOJ attorney who specializes in antitrust cases. I've helped him through the years, purchased several houses. His latest purchase was this August, just as these new rules were about to take place. I warned him of the new rules and asked him to read it, the settlement, and give me his opinion, and he did so. First thing he said is he would not sign such an agreement. Second thing he said is he would sue anybody who tried to force him into an agreement to view homes. He said under no circumstances should I as an agent require a signed agreement as a precondition to showing homes while there is a conspiracy amongst the competitors to require such an agreement. He said that this is a classic violation of antitrust laws, that mandated agreements are illegal, unenforceable, and qualify for triple damages. He said that individual agents will be liable as they are the persons coercing these agreements. And following illegal industry rules or mandates is not a legal defense. I have to tell you, my jaw hit the floor. And I said, I don't like these agreements, but oh my gosh. And then I started asking everybody I knew if anybody was aware of the risk that this rule is going to cause agents and brokers. And nobody is talking about it. You've heard it nowhere. The only thing that I could find is the state of Colorado issued a letter to all their brokers stating and forbidding required written agreements as a precondition to touring homes. And they sent out a letter to everybody and they have forbidden it. I read the letter and it mirrors what this attorney said. So I went, oh my goodness, what's going on? We've got to do something about this. So here's the letter from the state of Colorado. If you're interested, I will send it to you. But in so many words, it says they believe it's very problematic and they will not allow it. So I thought if Colorado can forbid mandatory agreements, so can Texas. And so I decided to see what I could do. I started out by writing a letter to the Texas Real Estate Commission, to the committee members. I wrote it to all of them to find out if there was anything that they could do to basically mirror what Colorado did and forbid these. So I was invited to speak at the semi-annual meeting. And let me tell you something. I couldn't believe it. I was the only broker in the state of Texas that showed up. And this meeting was 2 days after this rule took effect. And there was nobody else there. And so when I arrived, the chairman, Mr. Kestner, he greeted me and let me know he got my letter and was very happy that I'm bringing up this issue, that he thought it needs to be addressed. And so I gave my presentation. After the meeting, Mr. Pena and Chance Brown came up to introduce themselves and thanked me again very much for bringing this to their attention and that we definitely need to do something. I said, well, what do we do? And they're like, well, let me introduce you to the broker lawyer, the chairman of the broker lawyer committee, Mr. John George Jr. So this is the person that is in charge of changing all our forms every year. So he runs the committee. There's him and 12 other members of the committee. He's the lead, and they do discussions to figure out do we need to add or subtract anything from the contracts. So he and I had a very philosophical agreement about this issue. He then invited me to give him a call to discuss it further. So 10 days later, we had another phone conversation and discussed these issues at length. Now, it's Trek doesn't believe that they have the ability to act like Colorado did. So Mr. George suggested that I talk to the governor's office and see what they thought and what might be done to do something legislatively to change, to make these type of things illegal. Even though I personally believe, and the attorneys that we have hired personally believe, that they do have the authority, because it's this rule is blatantly against the law. However, on September 4th, I was put in touch with Mr. De Ochoa, who is the policy advisor to the governor's office. So I went down to the governor's office, and so it was he and his staff attorney. We spoke again for about an hour. So what did I learn? Well, I learned that all the government parties have a problem with these mandatory agreements. They find them problematic. They are trying to, quote unquote, run it to ground to see what we can do. But their thinking is that the only way to really explicitly do something is to get legislation passed. Or they wanted to know if I've already sued to get an injunction, which I have not. So they gave me the idea that, hey, maybe what we need to do is sue. Okay? Their thinking is that these are rules and not laws. And that's what they wanted to impress on me, that this is an agreement on paper between private parties, and that the state doesn't have the right to intervene until harm has occurred. The problem is, once harm has occurred, it's too late for brokers and agents. Once the harm has occurred, we're going to get sued, and we're going to get sued for everything that we've ever worked for. So as soon as there's enough closings to justify lawsuits, the class action lawyers are going to be knocking on buyers' doors. You can bet it. So we must stop this rule, either by legislation, court action, or by lawsuit. So here's what you need to know about this new rule. That number one, it requires a written agreement. Okay, and that is a problem. You can't require written agreements. It's anti-buyer, it's anti-broker, and it's illegal. The National Association of Realtors put brokers and agents into this legal jeopardy needlessly and for selfish reasons. Individual brokers are at very high risk of being sued out of existence. So, what is this rule? Well, it reads, unless inconsistent with state and federal law or regulation, which we believe it is inconsistent with federal law, state law, and regulation. So it requires that all Realtor MLS participants, which means you and me, working with a buyer, enter into a written agreement before the buyer tours any home. I'm urging you, do not follow this rule. The industry is blindly being led down the primrose path into a legal trap that will end in disaster for you, for me, and for everybody. So what's the problem with this rule? Well, there is a big difference between voluntary agreements and mandatory agreements. Voluntary agreements are freely entered into voluntarily by all parties. And it's good for all parties. And it is agreement amongst the parties. Mandatory agreements are by definition coerced. They're illegal and they're unenforceable, because you can't mandate that somebody sign something in order to get something else. You can't do it. You can't force them, which is what this does. It coerces the buyer into signing when they're standing at the house and want to get in. The only way they're going to get in is to sign your agreement. So what NAR does not understand at least it seems to me, I've talked to everybody, and they don't get that a requirement for agents to enter into a written agreement before the buyer tours any home is actually a requirement for the buyers to enter into a written agreement before the buyer tours any home. And you can't force buyers. So the next question is, what happens when a buyer doesn't want to sign? Which I've at least over half of the buyers that I've interacted with since this agreement have put up a fight and didn't want to sign it. And then half of those did sign it, but kind of under protest. Well, I don't think I should have to sign something just to see the house. And I agree with them. But that's the new rule, and that is that is the problem. Okay, according to NAR, a buyer may not enter any listed home until the buyer agrees to sign an agreement. That's the rule. And if a buyer refuses to sign, agents may not show them the home or any home. It's crazy. And that, my friends, is an illegal group boycott, which is defined as a collective action by two or more entities, often competitors, that agree to refuse to deal with a specific party or group. Okay, this meets the definition exactly. The two or more entities are the MLS members. We're all competitors. We're agreeing amongst each other to refuse to deal with any buyer who does not wish to sign. That is an illegal boycott by definition. All right, so before this rule, before August 17th, 2024, individual brokers, there are many companies out there who have this as their policy. We will not show homes unless you sign an agreement, a buyer agent agreement. That's their policy. It's perfectly legal. I have done it in the past. I try to get buyer agents agreement signed as soon as the client is ready to sign, because I want to protect my commission. All right? It's good business. However, now that this rule is in place, this is a illegal group conspiracy against the buyers. And so now, even if your company had a policy of written agreements prior to touring homes, now that everybody has to have that same policy, because now there's no brokers out there that can do something different. So now any broker who requires written agreements before the buyer tours a home is now conspiring with a group of competitors and to sign an agreement, which is a group boycott. So don't do it. Do not require, even if it was your policy previously. Well, who put this rule into place and why? Well, the rule is a result of the Sitzer-Barnett settlement. We were told that because of this settlement, we must change our practices, and we were all led to believe that Sitzer-Barnett attorneys put these rules into place. Now, they did put some of the rules into place, but they did not put this rule into place. And I only found this out recently. It's crazy. So NAR's reasoning is because they've been pushing this as an initiative forever to get they want agents and brokers to get buyer agents agreement signed as soon as possible, which I agree with, yes. But by making it mandatory, again, when you make it mandatory for an agent to do something, you're actually making it mandatory for the buyer to do something, and you can't do it. It's not allowed. Okay? So in an effort to protect agents, NAR has put this rule into the settlement, and I have talked to so many agents and brokers who are very upset about this, because anybody who actually does the business knows that this is just, it's not how business works. It's not how clients work. You don't show up to the door and stick something in front of their face and expect them to guarantee payment to you. It's just ludicrous. But they did it. And now they have put every agent and broker at legal jeopardy.
All right, let's go to the settlement. thoughts on what was great and not from your perspective, which is where we're probably going to disagree. Um,
I would first note that the mandatory buyer contracts were actually not part of the settlement. I actually suggested that it was at one point, and I got a communication from one of the plaintiff's attorneys saying I was dead wrong, and they were right.
Okay, so we just heard that NAR put the rule in place. So what are the problems with this rule? This rule violates the antitrust laws in 6 ways. NAR exercises its monopolistic power over the MLSs to enforce this rule, over brokers and agents to enforce this rule, and they do so by coercion of agents through the use of fines and suspensions. Both those things are illegal. It's an illegal boycott of buyers and agents who do not want to do business this way. It's an unlawful tying arrangement where you tie access to the listings with a mandated agreement. Again, unlawful. It's collusion among competitors, which means it's an unlawful restraint of trade. You cannot decide amongst you and your competitors, hey, we're gonna make them sign our buyer agents agreements, or we don't show them the house, and we're gonna make it that everybody has to do it. So then we can just say, hey, it's a rule and everybody has to do it. You can't do that. It's unbelievably myopic of NAR and whoever came up with these rules. And lastly, it's coercion of the buyer, because non-voluntary agreements are presumed coerced, and it's illegal on its face. So the question you have to ask, and this is the question that will be asked, is, Mr. Agent, can you prove that your buyer voluntarily signed your written agreement? And the answer is no, you can't prove it. Why? Because it's a mandate. And there's no such thing as a voluntary required written agreement. No such thing. Under a group mandate, all these agreements are going to be considered coerced. And even if the buyer signs with no protest while he's signing it, here's the insidious part for you. It's after the fact, the buyer can claim they felt pressure because they wanted to see the home. So they signed it really not knowing what was in it. They said I couldn't go in unless I signed it. They didn't go over it with me, line by line, word for word, which of course you're not doing. And if you did, you couldn't prove it. And so you're screwed. And if courts find these agreements to be illegal, which we believe they will, and if they find that they violate the antitrust laws, which we believe they do, agents and brokers individually will be liable for up to 3 times the amount of all commissions earned under coerced agreements. So the question to you, to the MLS, to everybody involved is, what's the purpose of this rule, and is it worth the risk? It's just not. There's no way that this is worth the risk. The risks are catastrophic. Now here's the thing you got to understand, that following NAR's rule does not protect you from liability. Just because you follow the rules doesn't mean that you can violate antitrust law. And courts, time after time, have held this up. Compliance with industry rules and standards and norms does not excuse illegal conduct. And this is illegal conduct, so don't do it. This rule is not a law. It is a collective action between competitors, which makes it illegal. So, ignoring this rule will not get your license suspended. And it may protect you against class action lawsuits, and it may keep you from losing everything that you ever worked for. However, you might get fined. You just might. And they might try to kick you off the MLS. Now here's what you need to know. If you do get fined, or if you do get kicked off the MLS, please contact me ASAP, because we are filing a class action lawsuit against all these MLSs. And we need people who have been fined. And so, now the thing is, I don't think you're going to get fined because I've been trying to get fined and nobody has fined me yet. I have voluntarily told on myself. I've been showing houses without any agreements, and I've let them know that I showed houses without the agreements, and they're hem-hawing me and not trying to fine me yet. So as soon as they do, they will get a nice lawsuit on their desk. So we'll see what happens there. However, if you do follow the rule, you're probably going to get sued and you may go bankrupt. I just don't think it's worth it. And if we stand up together and just refuse to follow this rule, you really can't get hurt because they can't get rid of all of us. We are the product. Remember that. We are the product. So I've got really good news, really good news. The John Ashcroft law firm has agreed to take our case. And in case you don't know who John Ashcroft is, he is the former Attorney General of the United States. He's the former governor of Missouri. And on his staff, he has the former Texas Attorney General. And they are willing to take the case. But they're not willing to take it for free. So we're going to have to pay them. And we'll get to that in a minute. But here's what they believe. They believe that the brokers and agents are in serious legal jeopardy if they follow this new rule. That this rule violates antitrust laws and probably fair housing laws. It puts brokers and agents in serious legal and financial risk. They believe the only way to stop this is to bring a lawsuit against NAR to prevent the enforcement of the rule. So, what should brokers and agents do? Join me and the former Attorney General to stop this rule. Do not rely on NAR, TAR, and MLS for legal advice. So I need you to sign my petition. I need you to contribute to the legal fund. I need you to send letters to your MLS and the associations. And we need you to state that to the MLSs that you will not follow this illegal rule. And the last thing you should do is do not require written agreements as a precondition to touring home. Do not say those words. Do not say it's a rule, it's a law, if you don't sign. Because, as a matter of fact, so when should you get a buyer agent's agreement signed? Well, because of this rule, you definitely should not do it before your first showing. That is off the table. Don't do it. So anytime after the first showing and your first offer is probably the right time to get buyer agent agreement signed. And really probably closer to the first offer. But you do what you want. Just don't do it before you tour any home. Because if you do, and then I would document the homes that you showed them prior to getting the document signed, so you can prove that you were not conspiring in this illegal conspiracy. So our goals, our legal goals, is to elicit the help of the Texas Attorney General. And this law firm says that they believe they can make that happen. It's also to file an injunction in federal court and state court to have the rule stopped because it's really a nationwide rule, and to file a lawsuit against NAR, TAR, and MLSs, again, preventing them from enforcing any fines or suspensions. So our legislative goals is to have the state of Texas to pass a law that will empower TREC to forbid any type of mandatory agreements. So that is what we're trying to do. So please, take your cameras out, take a picture of the QR code. It's a form, and please sign the petition. No matter what else you do, please sign the petition. We need an overwhelming force of agents stating that this is wrong and that we do not want the liability that this rule is going to bring to us individually. So please, take a picture, sign the petition. Next, I hate asking for money. I've never asked for money before, but because normally the people who take care of lawsuits and these things for us, which is normally the Texas Association of Realtors or NAR, the local association, well, they're causing the problem. We have to do this independently. The only way to do it is to raise money. So just to get the initial injunction filed is going to be about $30,000. And then it's going to be a lot more than that if it goes to trial. So again, if we just get a little bit from everybody, we can beat this back. And we might be able to get NAR to submit to our request and not to enforce this rule. You just never know. So anyway, please take a picture of this QR code. If you can contribute 100, please do. If you can't, do 50, 25, 10. Whatever you can do, please do. And if you can give more, if you're a broker of a lot of agents, you're really at risk. If you could give 1,000 or more, that would be great too. We need help. We've got high-powered attorneys. Everybody is really on our side except for the associations. They know that they are in a pickle. They know that they screwed up, and there's not a whole lot they can do about it. So we have to protect ourselves. So please join us. Thank you very much.